Call to order. Today's meeting of the Municipal Code Board is called to order on November 20th, 2019. Welcome, everyone. And would you please rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Agendas of today's meeting are on the wall at the entrance to chambers. Please remember to turn off your cell phones. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, then the affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak to please rise and be sworn in by the clerk.
Do you swear or affirm to tell the truth throughout your entire testimony?
Our first order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
Move to approve.
Second.
All in favor?
Aye.
Is there anyone here to speak to items not on the agenda? This would be your moment to come on up and say whatever's on your mind. Nobody? I'd like to make a note. Welcome back, Andy. Without you, you're really missed.
Sorry.
Okay. New business items. 4.1 is withdrawn. 4.2, case 217-19. Find respondents Decade Gulf Coast Hotel Partners at 521 South Gulf View Boulevard in violation of code for temporary signs, and issue an order with the compliance deadline and fine if compliance is not met. Are they here? Not present. Is this a?
It is not a declaration.
Not a declaration. So I need a motion on the.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? Inspector?
All right. Daniel Knight, sign inspector for the city. This is case 217-19 for 521 Gulfview Boulevard. The violation is for sidewalk signs. The city is asking compliance on or before December 20th of 2019 or a fine of $150 per day that the violation continues to exist. We are asking the board to authorize the following. After 3 months of the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies under the law. Compliance can be met for the sidewalk signs by removing all non-permitted sidewalk signs from the property and refraining from re-erecting any until first obtaining a sidewalk sign permit and following all the criteria and limitations presented in Table 3-1806 1A. This particular parcel has 2 separate hotels on it. The Holiday Inn and the Edge are all on the same parcel. So if the Holiday Inn decided that they were going to take all their sidewalk signs down and the Edge still had ones that weren't approved, the property itself would still be in violation. It's not per business, it's per parcel. This was on 8-5, this white A-frame style. There's actually one behind the box too. This was over on the Edge. You can see there are 3 out here. Taco Bus has an approved style one. It just doesn't have a permit. This was on 9/19. Also on 919, behind the sign, there's the prohibited style A-frame in front of the Holiday Inn. There's a better picture of it. And these are my... And this is just to show, the Edge had come in and applied for sidewalk signs, but I talked to zoning, and zoning said that there was still something needed on their end, and they never followed through with it. So those permits have not been issued. And then for the Holiday Inn, they just never came in to obtain one. On last inspection, the Holiday Inn did not have any sidewalk signs out, but the Edge still had 3.
But the owner of the property is the Holiday Inn Corporation?
The Decade Gulf Coast Hotel Partners.
Do they have a history of this, or?
That white A-frame sign comes and goes, at least on the Holiday Inn. I've spoke to the Edge. This will be the second year in a row that I've had to remind the Edge that they have to keep up their sidewalk sign permit. It is a yearly permit that expires 1 year from the day it's issued. And it's just an ongoing event, unfortunately.
Okay.
So there is my recommendation. Any other questions for me?
I don't think so. Why don't you tell us your recommendation?
We're asking compliance on or before December 20th of 2019, or a fine of $150 per day that the violation continues to exist.
Okay. Any questions from the board? No?
I think make a motion.
Go
I
ahead.
move to enter an order requiring the respondent to correct the violation on or before December 20th, 2019. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Opposed? That's carried. Thank you. 4.3, case 218-19, find respondents E&E 630 Properties LLC at 630 South Gulfview Boulevard in violation of code for temporary signs and issue an order with compliance deadline and fine if compliance is not met. Inspector?
The city is seeking a declaration of violation for this
Okay.
violation.
Okay, so I need a motion on a declaration.
I move to find the respondent was in violation of the code as referred to in the affidavit. In this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Opposed? That's carried. 4.4, case 219-19, find respondents Timothy D. Hannis at 2766 Dovewood Street in violation of code for temporary signs and issue an order with the compliance deadline and fine if compliance is not met. Are they here?
City is also asking for a declaration on this as well.
Thank you. Board?
Okay. I move to find the respondent was in violation of the code as referred to in the affidavit. In this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Opposed? Carried. 4.5, case 220-19, find respondent Splendid Wood Mart LLC at 2198 Gulfview Boulevard in violation of code for window signs and issue an order with compliance deadline and fine if compliance is not met. Are they here?
Compliance has been met here as well, so we are asking for a declaration.
Okay, good, I'm glad to hear that.
I move to find the respondent was in violation of the code as referred to in the affidavit. In this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Opposed? That's carried. 4.6, case 221-19, find respondent Zante of Palm Harbor LLC at 1808 Drew Street in violation of code for business tax receipt and outdoor storage, and issue an order with a compliance deadline and fine if compliance is not met. Are they here?
They're not. The violation for public nuisance, the outdoor storage of abandoned vehicle did come into compliance, but the violation, the zoning violation for BTR being required has not.
Well, listen, we'll do a declaration on the outdoor storage, and then tell us what we need to hear on the tax receipt.
Very good.
Okay, board?
You need first on that.
I need a declaration on the outdoor storage.
I'll do the declaration and then.
You first.
Okay. Case 221-19, move to find the respondent was in violation with regards to the outdoor storage, as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Opposed? Inspector, what can you tell us about the
Right.
tax receipt, business tax receipt?
All right, Daniel Knight again, sign inspector for the city. This is case 221-19, and it's a zoning violation of a business tax receipt being required. The city is asking compliance on or before December 20th of 2019, or a fine of $150 per day that the violation continues to exist. We are asking the board to authorize the following. After 3 months of the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedy under the law. Compliance can be met for the zoning violation of BTR being required by making sure that all current and future tenants operating a business at the property obtain a business tax receipt before operating their business. Compliance can also be met by having any businesses operating at the property without a BTR refrain from operating until a BTR can be obtained. It's going to be let's go here. This is over on Drew Street, excuse me, just east of Keene. The original complaint was the eastmost unit at 1820. A car dealership business went into that unit, and unfortunate for the other tenants there, it took up 3/4 of the parking lot with vehicles for sale. All the vehicles didn't have any plates. The business was never had a BTR, so all the cars became inoperable vehicles. Zoning said that business would not be allowed there unless a change of use was done at the property and approved. So that tenant ultimately ended up leaving, but it was after October 1st. Unfortunately, once all the cars and everything were gone, a new business went into that same unit, a tattoo parlor. They do not have a business tax receipt. They have talked to our BTR specialist and trying to obtain one, but they still need some state licensing. And then on 11/15, this Neo Cafe has moved in, grand opening, no business tax receipt. At the time the original notice was sent out, the business operating there was called Hippie High. They were current with their BTR, so there was no issue at the time, but being that it's taken a few months and compliance still hasn't been met, there are still businesses at the property that do not have a BTR. This is just to show that Neo Cafe is operating at the business location. They were closed at 9 a.m. on 11/14, but open at 10 a.m. at 1814 Drew Street, which is a unit at this plaza. This was from a Facebook post for the tattoo parlor. This is a better shot here. All the highlighted areas are saying grand opening. They're located at 1820 Drew Street. So they're advertising for business without their business tax receipt. And this again was for Neo Cafe, their Facebook page showing that they're located at 1814 Drew. This is to show that the Hippie High did have a BTR, but it was never renewed because they left. But Neo Cafe has not obtained one, And then this is for the tattoo parlor, showing that a BTR has not even been applied for.
You know, I think I got ahead of myself. We did the declaration on the outdoor storage, but they're not here, so we need a first motion on
Okay.
that business receipt, business tax receipt.
Case number 221-19, in regards to the business tax receipt, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? So, Inspector, there's one violation, no tax receipt,
Right.
and it's Zante of Palm Harbor.
The property owner,
That's what I have here.
let me just double check real quick.
I mean, that's who,
Yes,
that's who
Dante
we're,
of Palm Harbor. I have spoken with him, and he assures me that everything will be in compliance by the 20th, so I hope so.
okay.
So I have a question.
Yes.
Can a business request a BTR prior to moving into a location?
Can they request one? Yes, they can come in and they can try to obtain one. It has to go through zoning to make sure that that business is an allowable
Right.
use, but
But
yes,
they
they
can
can
get
get one
so that
before
the-
operating.
The landlord could have said, before you enter, you have to have the BTR.
Yes,
So
sir.
He's had prior control. Thank you.
Yes.
Any other question? We make a motion on the tax receipt? Second motion?
Mr. Chairman, I'll make that.
Good.
I move to enter an order requiring the respondent to correct the violations on or before December the 20th, 2019. If the respondent does not comply by that date, the board may order a fine of $150 per day for each day the violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Opposed? Good job, Inspector.
Thank you, Board.
Thank you.
Looks like you were busy there. 4.7, case 22-19, find respondents Kathy Collins at 1373 Campbell Court in violation of code for exterior surfaces and roof maintenance, and issue an order with the compliance deadline and fine if compliance is not met. Are they here?
Yes.
Come on down, ma'am.
Come on
Would you tell us your name?
Kathy Collins.
And Kathy, you heard the violation. Do you admit or deny?
Admit it,
You admit?
yes.
Oh, okay, thank you. Listen, if you just have a seat again in the front row, and then we're going to bring you right back, okay?
Okay.
This is our procedure,
You want a motion?
yes.
Okay. I move to find a respondent in violation of the case as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? Who's the inspector on this? Inspector
Turry.
Turry.
There he is.
Good afternoon, Board.
Good afternoon.
Inspector Yusuf Toure of the City of Clearwater, case number 222-19 at 1373 Campbell Court. There are two violations at this location. Code Section 3-1502B, exterior surfaces, rotten surface boards, pillars, and peeling paint. And Code Section 3-1502D1, roof maintenance. Notice of violation was sent out on 4/23/2019. The compliance date was for 5/31/2019. The certified mail, no return received mail or certified mail receipt. And then I posted the property with an affidavit of posting on 10/3/2019. This is a picture showing the way the roof looked 4/23/2019. This is another picture. This is as you enter the house, as you go in under the house, under the the soffit. You'll see on both sides of the house, there's missing boards, rotten. And there's another picture taken on 4/23/2019 showing peeling paint. And this is a picture taken on 6/27/2019 showing that the violation still exists. Another picture was taken 6/27/2019. And 6/27/2019, another picture taken showing still nothing done. Another picture taken 6/27/2019 showing peeling paint. This picture was taken 10/3/2019, still showing no action. The top is still on the roof. Still, 2019, 10/3/2019, no work done. No work done. I had to post the property with an affidavit of posting on 10/3/2019. And this picture was taken 11/17/2019, still showing no work done. We still have the top and peeling paint.
Any questions for the inspector? Thank you, sir. We'll
We need
bring
a-
you back.
We need his recommendation.
Well, I want to hear from the lady first. Come on up. Mrs. Collins. Mrs. Collins, you heard what the inspector said.
Yes, sir.
What do you have to say?
Well, I'm guilty of not getting it fixed. I've had some major medical problems, for one thing, and we bought some of the material to do the front area, the roof and everything, and had somebody set up to do it, and they never showed up. And this is my son-in-law, Tad, and he's come to help me and got the roof ready to repair. And so when they get the roof repaired, they can't do the porch area until the roof is done. So we got the material for the roof to be done, so it's ready, but they can't do that until they do the roof itself. And we have a contractor now, hopefully, a very good one. And
We have, I'm sorry.
That's all right.
My name's Tad Gage. I'm Kathy's son-in-law. We have Aries Roofing. I have paperwork in with Aries Roofing right now. So we're getting that back. We're also waiting for Fifth Third Bank. We're doing a refinance, working on a refinance, so that we can not only take care of the roof and the porch, but also a couple of other things updates that we'd like to do on the property itself.
What kind of time frame are you looking at?
The paperwork's in with Aries, so as soon as we get approval, as soon as we get the approval on them, we're about 2 weeks out from what Fifth Third said, from securing all of the cash to be able to pay Aries, who are also they're working with us to try to get it done under insurance. One of the things is that on the 1st of October, without notification, the mortgage company changed over, and the old insurance company said, as of 10/1, you have nothing. They're imposing insurance for the new company that took over, because we can't go out and shop insurance without having the roof repaired. So as soon as Aries gives me confirmation number on it, then they're coming out to start work.
So if everything goes the way you're thinking it's going to go, when do you think you will have your roof and the thing repaired by? What time frame? How much time do you need to get this all done?
I would assume with everything, even if the insurance doesn't go through and we get the refi on it, before Christmas, it should be completely done. Because we're 2 weeks out, and as soon as Aries can put us on calendar,
Yeah,
we want to get them done.
okay.
Well, the
That's
thing
not
is, you're
reasonable.
running into the holiday season.
Right.
And things don't always flow the way they go. But I'm thinking, if somebody gave them into January, if the city would be okay with that?
I'm okay with that.
Yes, it's okay.
In the January?
January is okay.
Middle of January,
How about January 24th?
January 24th.
Listen, unless you have anything else, so why don't you just have a seat again?
Okay?
Well, I need to hear the city's recommendation, and then we'll make a motion.
Yes, sir.
And thank you for what you told us.
Yes, sir.
2020.
Recommendation for case 221-19 is for exterior surface and roof maintenance, compliance on or before October 12th.
Sir, 222-19,
Yes,
I think you said 221.
no, 222.
Yeah, right. I just want to make sure I heard that right. I'm sorry. 222.
And that compliance date's not gonna fly because we're in November now.
Oh, okay. Compliance will be December.
December.
Thank you.
Yeah.
Recommendation for case 222-19 for exterior service and roof maintenance. Compliance on or before December 20th, 2019, or a fine of $150 per day per violation. We are asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. Compliance can be met for exterior surface by repairing all rotten wood and repainting all repairs made. Compliance can be met for the roof maintenance by removing the tarp off the roof and have it repaired to be safe, secured, and watertight. These are just pictures that I took before, just to show
I can
the
make a
conditions.
motion. Okay, we'll make a motion now. Thank you.
Thank you, sir. Hey, Bob, hold on. Would you come up, please? So I think the board's in agreement here. We're going to make you a motion extending your time. Okay?
Okay.
But I just want to remind you, there's 2 violations. There's the roof and the exterior.
Right.
And do you have the inspector's phone number?
Yes.
So, I mean, if you have questions or anything like that,
Oh,
there you go. Thank you. Okay.
Want a second? Okay. Okay. And if you run into problems, let them know, okay?
Yeah.
Okay. I move to enter an order requiring the respondent to correct the violations on or before January 22nd, 2020. By God, here we go. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Opposed? That's carried. Good luck.
thank you. Thank you so much.
Thank
You're
you.
quite welcome. Okay, moving on here, 4.8, case 223-19, find respondents Dumitru Vioni and Inaka Vioni, and I apologize if I'm off on that, at 1364 Friend Avenue in violation of code for boat parking and residential grass parking, and issue an order with the compliance deadline and fine if compliance is not met. Are they here? Come on down, sir. Would you tell us your name for the record? And were you sworn in?
Yes, sir.
Oh, good. Dumitru?
Yes.
Hey, Dumitru. Do you admit or deny?
I admit, yeah.
You admit?
Yes.
Thank you. Sir, if you just have a seat in the front row, we're going to bring you back, okay? And I need a motion.
Okay. I move to find respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? Inspector,
Yes.
you're up. This is 223-19.
Well, yes.
No parking.
Inspector Yusuf Toure of the City of Clearwater Code Compliance, case number 223-19 at 1364 Friend Avenue. There are two violations at this location. Code section 3-1407, A3, A3B, A5, and A7, boat and trailer in excess of 20 feet not fenced. And code section 3-1407, A5, and A7, multiple vehicles parked on the grass. I sent two notices of violations. One was sent 2/13/2019 and 7/1/2019. The compliance dates were 2/28/2019 and 7/15/2019. I posted the property with an affidavit of posting on 10/2/2019. This picture was taken 6/7/2019. You can see the boat is out there, not fenced, and it's longer than 20 feet. And this other picture was taken 6/20/2019. You can see he put up a fence, but the boat is still exposed, and he has multiple vehicles in the backyard. And another picture was taken 8/2/2019. Still, the vehicles are there. And this picture was taken 10/3/2019 when it was posted with an affidavit of postings. That's just the photo of the affidavit of posting. 10/3/2019. Still, the vehicles are behind the fence, including the boat. And this picture was taken 11/17/2019, still showing the violations existing. This also was taken 11/17/2019. As you can see, now there are more vehicles added onto what was already there.
Well, any questions for the inspector? So why don't you tell us your recommendation? You're there, you might as well just tell us.
Recommendation for case 223-19 at 1364 Friend Avenue. We have two violations for residential parking and grass parking. Compliance on or before December 28, 2019, or a fine of $150 per day per violation. We are asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
Now, do you want December 20th? Because on your PowerPoint, you have December 18th.
Yeah, this is what happened. We had a problem with at the office, so I did change it on my computer, but actually it's not changed here.
Okay,
So that's why that's the discrepancy.
It's the
But I did
20th
change
then?
it earlier, so it's supposed to be December 20th.
Okay.
I have a question too. The first date of your posting on it was when? February of this past year? And this is already December of this, almost December of this year?
Right.
And nothing's been done in all this time?
Yes, nothing has been done.
Thank you, that's what I was asking.
Other than the fence.
Well, yeah, but the
The
fence
one-
is not
And he's added
completed
more
because you could still see the
Yeah.
boat.
Yeah. Right. A lot more there.
Okay, sir, thank you.
Well, now, he needs to say what they need to do to meet compliance.
Well, okay, let me go to the
I
compliance.
think you told us, so we changed that to the 20th.
Yes, it's the 20th. Like I said, I already corrected it, it just didn't show up here. Compliance can be met for residential parking by parking the boat on an approved surface such as pavers, concrete, or asphalt. Also have it screened with a 6-foot solid fence, wall, or hedge, which may require permitting or remove it from the property. And compliance can be met for the grass parking by removing the multiple vehicles parked in the backyard permanently. Because they can't be there.
Okay.
And Inspector, can any vehicles be parked on the grass in the backyard?
You cannot have any
You
vehicle.
can't have any
You
vehicles.
cannot have any vehicle there. Now, if you consider the boat as a vehicle, it has to be on an approved surface, which requires permitting.
Okay, Inspector, thank you.
Well,
Thank you very much. Dimitri?
yes, sir.
So you heard what the city is saying.
Yeah, I heard that.
What do you have to say?
Just come back from Europe. I got some funeral in my family. Just come back in even a month. And I'm gonna enclose the whole property. I'm gonna build a fence. And the boat, I got some work to do. I'm a master mechanic. So I work in the boat, and the vehicle, the Nissan, the white Nissan is my car. It's running, but I park it over there for my wife to park her Jaguar because I don't have a 2 parking spots. The property is in the front.
Are you clear what you have to do to comply?
Yeah.
Oh, okay.
You can, excuse me, Mr.
No,
Chairman.
it's okay.
You can enclose your backyard, like you say, with a fence all you want to, but you still can't park vehicles back there on the grass.
All right, so if I build a slab of concrete, it's okay?
Yeah, if it's approved, if the engineering department approves it, you have to get their approval first.
Yeah, I'm looking to buy a steel building.
But the fence itself won't solve the problem. The problem is parking all those vehicles on the grass. You can't do that.
Yeah, see, that's why I asked, are you clear?
Yeah, I understand that.
With compliance.
So where are you gonna park the cars?
That's
We
up to
don't
you,
know.
anywhere but on the grass. That's your problem.
That's your problem.
Yeah, because if you don't comply by the deadline, that 150 a day kicks in. You don't want that.
Nobody want that.
No, that's a lot of money.
And the thing is, to do what you propose to do,
Yeah, I
okay, it sounds
understand.
good, putting a concrete pad and all that, you're gonna need a permit.
Yeah, I know that.
Okay, you think you're gonna get a permit by December 20th?
Mm,
That's not gonna happen.
It's not gonna happen.
No. And the other part that's not so good is, as was pointed out by Sheila, this has been going on since February.
And I just bought
So
it.
you haven't been out of country since February, have you?
No. I just was out of country October.
Okay.
You know.
Okay,
no-
so here's the thing, you've got, I think, more to do than you realize, and you're gonna have to go through some steps to do that, and it's gonna take some time.
Yeah, that's true.
Yeah, I think you have a problem.
Dimitri, I have one more question for you. You
Yes,
say that you're a mechanic,
I'm a master mechanic.
and all those vehicles in your backyard,
Yes, they're my vehicle.
they're yours?
Yeah, registered under my name, yes.
Are you working on those vehicles?
Yes, I got one of
Do you
them.
work on any other vehicles that come your way?
No, there's mine. That's
All of
mine.
them are yours, okay.
And my own stuff.
So Dimitri, you know, I wish the best for you. I don't want to see you come in under that radar where you're going to start getting fined 150 a day. That's a lot of money.
Yeah.
And you don't want to come in here as a repeat,
No, I don't.
because then they're going to put a lien on your property.
But if I bought a building, a steel building, and just got a permit to.
We don't know that here. We're not in that business.
You have to talk to the inspector.
You need to talk to the inspector. We can give you time, like right now, they're saying December 20. That's right around the corner,
Almost.
you know? I mean, yeah, you have a problem here. You need to take it serious, or it's
Yeah.
going to compound.
So you may want to come up and make a suggestion as for a different date for you to be in compliance.
Probably in the beginning of next year, January, something like this.
Dimitri, you also have to consider if you put up your fence you're talking
Yeah.
about, that needs to be permitted as well.
Yeah, I know that, I know,
Okay.
I know.
Anything you put
Alright.
back there, I would go through the inspector. I would be his best buddy.
Yeah, I got a permit for the fence,
Okay.
but I was, they told me I have to move it a couple of feet back, because it was not line up with the,
Yeah.
whatever, you know.
Demetra, I think the board would be willing to push this up another 30 days, but in my mind, I just hope you're clear with what you have to do.
Yeah, I understand.
You have the inspector's number. He's your pass,
Okay,
okay? Or this will get a whole lot worse. You don't want that. We don't want to see that on
nobody
you.
wants, not just me.
Sorry,
Okay.
Christmas coming up in between.
The board?
I'm not making any arrangements. I've made enough.
I move to enter an order requiring the respondent to correct the violations on or before January 22nd, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Opposed? That's carried. Well, good luck to you, sir.
Sir,
Okay.
you need to maintain contact with the inspector as your
Yeah.
progress goes, and they can work with you.
Okay,
Thank you,
But,
Neil.
you have a lot ahead of you.
I know. No,
Well, good luck, and good luck with your family.
Thank you.
You're welcome. 4.9, Case 224-19, find respondents, Ovid Sub-Billion at 1533 Rosewood Street in violation of code for residential rental tax receipt, short term, is there more to that? Rental, and issue an order with compliance deadline and fine if compliance is not met. Are they here? And this is Inspector Phillips.
And Chair, this would be a declaration.
Yeah, we went through a run last time.
We did.
It's a repeat.
I'll go ahead. I move to find the respondent was in violation of the code as referred to in the affidavit. In this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Opposed? 4.10, case 233-19, find respondents Mohammed Fire at 763 Mandalay Avenue in violation of code for residential rental business, tax receipt, and issue an order with the compliance deadline and fine if compliance is not met. Are they here?
Present.
Not a,
Attorney's present?
not a declaration?
No.
No. Okay.
Who's present?
Sir, would you tell us your name, please?
James Lampathakis.
And James, I know you've been,
Lampathakis.
I know you've been sitting here a while. You were sworn in?
Yes, I was.
Okay. And the city okay with the representation? And, sir, do you admit or deny?
Deny.
You deny. Okay.
He's representing.
Listen, I'm going to have you sit in the front row. That's our procedure. We're going to hear from the inspector, and then we'll bring you back. You're welcome.
Good
Inspector
afternoon,
Phillips.
Board. Julie Phillips, Inspection Specialist. I'll be doing a presentation for 763 Mandalay Avenue, case 233-19. This will be a two-part case. The first portion of this is going to be rent without a business tax receipt. The second presentation will be a repeat violation for an illegal short-term rental.
Could I hold you one second?
Absolutely.
So there's two violations or two parts?
This is two separate PowerPoints. This is the first PowerPoint for a business tax receipt.
Oh, okay. Tax receipt and repeat. Repeat's not on my language here.
It's the next case.
Next one.
Okay.
There's two separate cases.
Oh, okay. Okay. I'm sorry. I just
That's
went.
okay. So there is one violation at this property. It violates code section 3-2302 for a residential business tax receipt required. And a notice of violation was sent on August 7th, 2019 with a compliance date of September 6th, 2019. And an affidavit of posting was done on September 17th of 2019. This just to show our Acela program. The only BTR for a short-term rental of this location was actually issued in 2005 to the previous owner, which was Elizabeth Criticus. And this is to show that the owner, Mohammed Fayor, purchased the property on November 19th of 2015, and there's never been a business tax receipt for that location since he's owned it. This is to show that the property is advertised on the Airbnb.com website, 1 block from the beach, 2-bedroom, 1-bath home in Clearwater by Paul, his host, and that picture was taken on September 26, 2019. This is to also show that the host offers a 1% off a week stay or 2% off as a monthly discount. And this is also to show that I tried to book the property from November 11th to the 11/15 and had a bill for 4 nights of $837. This is also to show that the same property was rented 3 times in August. It was also rented 4 times in September. And I'll let the board deliberate.
Okay. Sir? So on the first part, the city is saying that Mr. Fryer is in violation of no residential rental business tax receipt, and you deny that.
Yes.
Would you tell us why?
So Mr. Faur has rented this property out on a long-term basis, on a 1-year basis. And he has rented it out to that host, Paul? Yeah, so he's rented out to him. He's the one who has improperly leased the property out for a short-term basis. So I have a written lease here, if you'd like to see it, I can show it to you. But he rented out for 1 year, and then unbeknownst to the owner, this individual turned around and leased it on a short-term basis on Airbnb. So we sent him a notice.
No, I'm sorry.
No, that's okay.
So we sent him a notice in July, I have a copy of that, if you want to see it, to cease doing this, and unfortunately, he kept doing it. My client talked to him when he vacated another property. This is on Lantana. He has 2 leases, 2 sets of people on both leases, some relatives on the other lease. So he ended up going out there, and he was continuing to do this behind the owner's back. My client had no knowledge he was doing this. At this point in time, he's been removed from the property, and the property is vacant at this point in time, and my client is not planning to rent it out again. He's actually going to put the properties for sale.
When did Mr. Fiore remove that tenant?
That he left at the end of October.
This year?
This year, yes, sir.
Okay.
Just recently then.
Just recently, yes. When we received these notices, that's when he talked to him, and he got him to move out on this one.
Right. Is there anything else you'd like to add to this case? And I'll tell you why, I've been sitting here, I'm in my 9th year now, believe it or not, doing this. And I've heard all kinds of cases come before us, and it always boils back, no matter what happens on that property, it always boils back, it's the owner's responsibility. The owner should know what's going on that property. And I know sometimes, like in a case like this, it might be hard because this is all done on the computers, and maybe Mr. Fiore lives out of town. But I've never seen one go differently. It always goes back to the owner.
I understand that. And, you started off by saying this is an equitable board, And so I understand that he has liability and responsibility in this type of matter.
Right.
But he's not the one that's benefiting. He's not the one that's doing the act. When he found out about it, I sent him the first notice, and then we got the second notice. That's at that point in time when we got him removed from the property. He is an emergency room doctor. He lives in Tennessee. I'm sure you have a lot of people that own property on the north end of Clearwater Beach.
Right.
That are out of town, out of country, out of state. And so I understand that. But in this situation, with at least the business tax receipt, he's not going to rent this out anymore. That tenant has been removed. He's not going to rent it or any other properties he has, and he's going to put them all for sale. So I understand that, but at least here there's some mitigating factors, in my opinion.
So here's the thing, it sounds to me that your client owns these properties as an investment.
Yes, sir.
Okay, so he's in the real estate business, he's a landlord. So he's not unwise in what he's doing. Because, we had another case here once before, I think it was 839 Lantana. And the people, they had a lease and so forth and so on, but that was last year. And if I'm right, your client also owns 839 Lantana, or his family, okay? So he had that same arrangement there, and it was only until July and then subsequently moving out in October of this year that he realized that the same thing was going on. So I thought I had the tattoo stupid removed a long time ago, but apparently it's coming back. I find this really to be repugnant.
He is not a professional landlord.
Oh, he is an astute businessman, and he tries to play the angles. At least that's my understanding of everything that's been presented for the last 3 years on 839 Lantana.
I understand.
Okay,
But
so-
he hasn't appeared here before, or he hasn't had a representative here before.
Oh, yes, he has.
No.
Yeah. The woman showed up, she said, I have a lease, all that stuff. That was her representative. She said, I'm representing him.
I'm not aware of that.
Well, and I could,
But
that's okay.
Let's make sure that we're only discussing
This
Right.
case, okay, and I don't mean to.
Right.
So I'm just trying to say that I have problems understanding that he didn't understand the relationship and what his tenant was doing. That's my problem, so.
Anything else you'd like to tell us?
No, not at this point in time.
Mike, did you have something?
Not for council, but if I may ask just one clarifying question.
Yeah, Mike, hold on, I'm gonna bring her on. Would you have a seat
Yes.
again, please? Would you, Inspector, come back, please? So we have some questions for you, Mike.
Yes, and Inspector, in terms of a business tax receipt, does it matter if the individual is renting long-term as opposed to short-term?
You're required to have a business tax receipt if you rent at all. It doesn't matter if it's a year, then of course you would have to have it, and there's never been a business tax receipt for this location under Mohammed's name.
And so, the gentleman can either do one of two things, if I understand. He can gain a business tax receipt, or he can just never rent out again.
Correct.
Inspector, correct me if I'm wrong, hasn't it always been our policy, as you and other inspectors stood before us, that we always go back to the owner on these violations?
It is always the owner's responsibility, the owner of record on property appraiser, yes.
Thank you. Thank you. Is there anything else you want to tell us? I don't think you gave us your recommendation, did you?
I think I'll speak to the recommendation, and I have a lot more to tell you in my next presentation.
So let's do the recommendation on this one, and we'll move on. We'll
So
move on
my
to-
recommendation for case 233-19, there's one violation for business tax receipt required. I'm requesting compliance on or before December 3rd, 2019, or a fine of $250 per day for each day the violation continues to exist. After 3 months from the recordation date of such lien, if the lien's fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal equitable remedies available under the law. Compliance can be met for the business tax receipt required by filling out an application and paying the required fee, or by not renting the property.
Okay, that's pretty clear.
Yes, it is.
Any questions for the inspector? Thank you. Sir, would you come back, please?
Of course.
So we're going to make a motion. Is there anything else, any questions for the attorney?
No.
No?
No.
No. Mike? No?
The date was December 3rd?
Yes.
Anything else you'd like to add, sir?
No, thank you.
Okay, board, let's make a motion.
Just so as Mike said, the board is aware, an affidavit of compliance will be issued after whatever date if he is not renting again.
Okay.
For
You
this
want that in the
particular
language?
No, I just want you to be aware, that's what we
right.
will look at, depending on whatever day you put for that time period. So if you put December 3rd, if we have no knowledge of renting from this point forward, then you will receive an affidavit of compliance.
And if he still is renting past that
Then you
date?
will receive an affidavit of non-compliance.
But what if he gets a BTR?
Then he's in compliance.
Then he's
So
in
you'll
compliance,
get,
right.
if those two things occur, you'll
Yes.
get the affidavit of compliance.
Okay. Let's go ahead and make a motion.
I move to enter an order requiring the respondent to
First
correct.
motion, I'm sorry.
I'm sorry.
The first motion,
Well, we had to
We did,
deny.
did we?
We had a denial.
he denied
You
it.
need to make a finding.
Okay, I'll make a motion. First motion, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor? Opposed? Second motion?
Okay. I move to enter an order requiring the respondent to correct the violation on or before December 3rd, 2019. If the respondent does not comply by that date, the board may order a fine of $250 per day per violation for each day the violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Opposed? That's carried. Okay. Moving on here, 4.11, case 234-19, fine respondents Mohammed Fior at 763 Mandalay Avenue in repeat violation of code for short-term rental and issue an order that a daily fine be imposed for each day the repeat violation existed. Sir, how do you plead on that one?
Denied.
Denied. Okay, if you'd have a seat, please. Thank you. Inspector? Well, we can make a first motion on that then, right?
No.
No? We
It's a
wait?
denial.
He denied, so,
Now we hear.
right.
She may be wrong.
Yeah, oh, yeah.
I'm sorry, it may take a moment. It's a very lengthy presentation, so I'll ask for your patience in advance.
Okay.
Again, Julie Phillips, and specialist. I'll be doing a PowerPoint presentation for 763 Mandalay Avenue. This is a repeat violation, case 234-19. There is one violation at this property for an illegal short-term rental. It violates Code Section 1-104B for a development code violation and Code Section 3-919 for prima facie evidence, which is advertising. The definition of a residential use means a permanent place of residence for a family. A residential use located on residentially zoned property shall not include rentals for periods of less than 31 days or 1 calendar month, whichever is less, or which is advertised or held out to the public as a place rented for periods of less than 31 days or 1 calendar month, whichever is less. A residential use located on residentially zoned property shall not include an interval ownership, fractional ownership, or a time-sharing unit. A definition of a repeat violation. A repeat violation means a violation of a provision of a code ordinance by a person who has been previously found through a code enforcement board or any other quasi-judicial process to have violator who has admitted violating the same provision within 5 years prior to the violation, notwithstanding the violations occur at different locations. So this is a copy of Property Appraiser, and this is to show that Mohammed Fayor owns 937 Bruce Avenue, 839 Lantana, 843 Lantana, and 763 Mandalay Avenue. The property was actually posted with an affidavit of posting and notice of repeat violation on September 26, 2019, and certified mail receipt was received on October 4th, 2019. On September 30th of 2015, one of his locations, 937 Bruce Avenue, case 8715, was brought before the Municipal Code Enforcement Board and was found in violation for an illegal short-term rental. The owner, Mohammed Fayor, was given 10 days to comply, and compliance was met and the case was closed. On May 24th, 2016, 839 Lantana Avenue, case 68-16, was brought before the Municipal Code Enforcement Board for an illegal short-term rental and was found in violation for a repeat violation and was fined $500 per day for 6 days, totaling $3,000. Fine was not paid, and it still has not been paid. On August 25th, 2016, 843 Lantana Avenue, case 69-16, was brought before the Municipal Code Enforcement Board for an illegal short-term rental and was found in violation for a repeat violation and fined $500 per day for 12 days, totaling $6,000. The fine was not paid, still has not been paid. On April 24th, 2019, 839 Lantana Avenue, case 59-19, was brought before the Municipal Code Enforcement Board for an illegal short-term rental and was found in violation for a repeat violation. Fined $500 per day for 63 days, totaling $31,500. The owner was not present, fine was not paid, still has not been paid. I received an anonymous complaint actually in July that this location was being rented short-term, and it was owned by Mohammed Fayor. So I did go on the website, which is airbnb.com, on August 2nd, 2019, and it was being offered Clearwater Beach House, 2-bedroom, 1-bath home. The availability is a 1-night minimum stay, and if you look at the calendars of August and September, we require 31 days or 1 calendar month, and that's not how it's being rented. I also tried to book the property from October 12th to the 19th for 7 days and got a bill for $2,108. On September 26th, I went back to the same website. Same advertisement, 1 block from the beach, 2-bedroom, 1-bath. This time the availability changed to the host offering a 1% discount if you stay for a week and 2% for the month. And then I tried to book that from November 11th to the 15th for 4 nights, $837. And I also wanted to show that in the reviews, they had 3 reviews for August. There was 4 reviews for September. And then I decided to go ahead and email the host. I have several actual of my own accounts that I use. This one was Sarah Daniels. And I did write to Paul and I told him I'm having trouble with the website. I'm trying to book December 1st through the 7th and would like to bring my dogs with me. Is this date available and do you allow pets? I did that on September 26th. He did answer me at the top with the arrow down. It says the dates are available and yes, we love dogs. He then proceeded to send me a bill, which was $1,919. This is the picture of the front of the house located at 763 Mandalay, where I did my affidavit of repeat violation. That's a better shot of it. I went back to the website on the 27th, same listing. Tried to book it again from November 25th to the 30th for $1,083. Again, offering a 1% discount for a week, 2% for the month, and looking at the calendars, they're not booked for 31 days or 1 calendar month. Again, showing 3 times the property was booked in August, 4 times in September. On the 30th, same listing, this time trying to book it from November 26th to the 29th with a bill of $680. On October 3rd, same website. This time, November 21st through the 29th for $1,727. Again, looking at the calendars, they're not booked for 31 days or 1 calendar month. Again, on October 9th, same website. Again, this time trying to book it December 5th through the 9th for $850. Again, on October 18th, same website. This time from December 14th to the 21st for 7 nights for $1,465. Again, on the 22nd, 12/7 through the 11th for $825. Again, showing the 1% for a week discount, 2% for a monthly discount. On the 22nd, now we added an additional booking. There were 4 in September, now there are 5. And if I turn the page, it's actually 6. So when you go back, the bottom is Lucky, I'm sorry, and then it went from under Lucky to Anthony. So it was booked 6 times in December, or September. Again, I tried to book it from December 7th to the 11th, $825. And then finally, on November 7th, the property was posted for today's hearing for the business tax receipt and the illegal short-term rental. Hard to tell if it's vacant. There's a lot of beach items on the front porch, a table in the front yard, and I'll let the board deliberate.
Okay, thank you, sir. So you heard what the city just showed us. My question to you is, I'm a little fuzzy there. The owner kicked out the tenant, what date did you say?
The end of October.
The end of October. And your last booking was when on there? So he's booted out of there and
There's so many.
and he's still booking?
I don't think so. He's not there anymore.
He was in the time frame.
Oh, okay. I just want to be clear on that date
Yeah,
there.
I believe that when she did it in October. All of her dates were in October.
Right.
And he's still allowing that, but he's out of the property. You haven't seen anybody there since.
Bodies, no.
No,
Okay.
there's nobody there. It's vacant. It's a vacant property.
Okay, so we heard what the city presented to us. What do you have to say?
Well, I will start by saying again that my client in 2016 was the first time that he had a violation. And at that point in time, he wasn't aware of the code. I know he's responsible to know what the code is, but he wasn't aware when he was renting it short term. Thereafter, he learned his lesson. And he said, okay, I've got to rent it long term to whoever I rent it to. So he's entering 1-year leases that are 1-year leases. They're not anything other than that. And so this tenant, this Paul, and on every one she showed, she didn't show Dr. Faour, she showed Paul. Paul is the person who's on the lease. So he's the one who came up with this brilliant idea and said, I'm going to pay for this property that rents $2,000 a month. I'm going to pay $2,000 a month and then I'm gonna sublease it to other people and make lots of money. And if he's a shrewd businessman, he's knowing that I'm never gonna be liable. I know the owner is gonna be liable. So every notice that came in over the years, or over the year, was either mailed to the address for the violation, or was mailed to, or was posted on the property. Well, if the subtenant got that notice, he either threw it away, or he gave it to the tenant, Paul, or if Paul got it, he just threw it away. Because he's saying, this is fantastic for me, I'm making lots of money, and there's no way I'm gonna be liable for it until the clock ticks, you know? And the clock ticked when we got the final notice, and we realized we had to remove him. So my client had no knowledge of what was occurring. He had no intent on violating the city code. He actually was trying to do the right thing and lease it for 1 year to not be in violation of the code, but the subtenant, the tenant, turned around and subleased it to other parties. I know he's liable. I just want you to consider these factors and these circumstances, and hopefully they're mitigating so that it's not him. The first time it was him, I understand that. But the second time after he learned that, he knew he had to rent it for 1 year. So he didn't profit in any way by this Paul host tenant. He didn't put any money in his pocket, just the rent he was getting, the $2,000, Paul was put in his pocket. So there was no knowledge, there was no intent, and there was definitely no profit. You mentioned it earlier, nobody wants to repeat fine. Nobody wants to get hit with $500 a day. Now, I need to go back because you brought up Lantana. And so what the city's trying to do now is to say that he's a repeat offender, even though it's not in this property, but a different property. And if you look at her slide, for the one that occurred at Lantana, there was the $31,500. He was not present at that thing. He had no representative here. He had nobody here, okay? And he wasn't aware of that. Now what happened? The address that he has on his deed is the property address. Understand? That's where the city has to send it. But the city, as you look, they did a lot of research. I mean, they spend a lot of time. I don't know how many days she put up there. She kept checking, and checking. So now I'm going back to Lantana because we're talking about the repeat violation, okay? So she brought it up. Repeat, I've got to address it. So if they're going to try to connect these two properties, Lantana and Mandalay, well, the tax bill on Lantana was going to the property address. He never got those notices. His fault. He's got to change it. But if you're going to connect these properties, if you look at the deed from 11/9/2015 that she said, and she also had the slide up there, and it's got 4 properties he owns. 10 seconds to click on that button, and you have the deed here, which has his Tennessee address. So if you're going to connect the properties against my client, then you at least should consider connecting them for my client and saying if the city had spent nearly as much time as they spent to research it, they would have found that on this deed is his Tennessee address. Now, if he had gotten that notice in April earlier this year, I would have been here, he would have been here, we would have been responding, and we would have removed that tenant at that point in time. And so, while the first one still exists, that one wouldn't exist. And that's a lot of money. It's $31,500. He owes over $40,000 on that piece of property. I mean, he's not happy. Understand? But I'm here to try to give you the other side of the story. He's never had a representative here because of the notice issue. And, you know, due process is one of the most important elements of our law, of the board, of any law. So if you don't get notices and you don't show up, it's not because he just, well, let him find me, this is great. Again, he's not making the money. So if they had just spent a little bit of time, 10, 15 seconds, pulled up that deed, when those 4 things are on there, just clicked it on there, they would have found the Tennessee address. They would have notified him in April, and then he would not, I wouldn't be here today, because this whole thing would have been resolved at that point in time. So I'd like the board to at least consider that in this case, at least to consider that it's not a repeat, because he cured the defect on this property, the tenant is gone, he not ran into anybody else, I can guarantee you that, and he's going to sell the properties. Once this gets resolved, I've sent an email to Attorney Funio that my client's intention is to sell it immediately when it gets done. So he didn't have the intent, didn't have the knowledge, received no profits, and I think the notice issue connects both of the properties. If the city's going to use it, then I would suggest that they also have to be held to this minor standard. In addition, not that they have to do this, but if you Google him, there's only one Mohammed Fawr, and he pops up immediately. And this deed for this property on Mandalay has the Tennessee address. Now, I just want to say one thing, because I think it's important. I live on Clearwater Beach. I live on the north end of Clearwater Beach, and I live in a house on the north end of Clearwater Beach, and I've lived there for 26 years. So I understand the issue here, but I also believe in the rights of the owner, and I also believe in notice and fairness, and as you mentioned, equity. So I hope the court considers, because he really was trying to do the right thing, no matter if you think he's a crook and a professional. The professional here is Paul, the host. And the city is going to have this problem again, if they haven't already had it. You know, maybe you have. But there's going to be innocent people that are going to try to rent their properties on Clearwater Beach, and somebody's going to say, let me pay $2,000 and short-term rent it, and then we got a problem.
I have a question.
Yes, sir.
The lease that he had with Paul, the
Yes.
tenant, and all that, did it have right to sublease
No,
in it?
no.
Okay, so then, I've been a landlord in the past in multiple properties all up north in Kentucky. And the one thing is, you always want to touch base with your tenant, if you're going to get into that type of business. Know what's going on, seeing that your property is not being damaged, okay, and that they're living, and things are good, and that it is what it's supposed to be, that their water's running and so forth, and the mechanicals are right and all that. So if you're going to do that, you need to do it right, or it gets costly. And I guess it's going to get costly.
I'm sorry, I didn't.
I mean, if you don't pay attention to your business, you lose, it becomes very costly.
So,
because he was neglectful. Your client was very neglectful. He had a contract with this person, and he wasn't making sure that his tenant was living up to that contract and to that lease. Was he?
Well,
he would have known what was going on had he maintained contact.
I don't know. I mean, I would say no. You don't know what's going on. I mean, I own properties.
If you don't want to know, then maybe you don't know.
I mean, I own properties. When they're sending me checks and they're not calling me for maintenance, I'm pretty happy. You know. So I don't know what they're doing. If they're doing something illegal, it's a burden to put on the owner and every owner. Now you got to put this burden on every owner on Clearwater Beach and say you have to check. How often? Would you go knock every week, every month? No, you don't do that. I mean, landlords. I would say no landlord goes and says, "How's it going today?" You know? No.
Not every day. No.
Or every week or every month.
Maybe once.
If you're in Tennessee, you know, or if you're in England, what do? You know, you're collecting the rent. Thank you for the rent. I appreciate it. Oh, you need the AC fixed. You send the AC guy to look at it. You don't send, you know.
You know, we all each run our businesses differently, don't we?
I think the general, reasonable way that people do it.
So what if you don't look out for yourself? You can get the short end of the stick. And it looks. This man did Mr. Fowler dirt, apparently.
Yeah, I would just like you to consider it. It's all I can ask.
Sure enough.
You know, all of the factors. So that was my.
I just want to assure you that the only case before us is the property on 763.
Yes, sir.
Today, we don't care about the other ones. I mean, we're here to review the case that's before us.
I understand that, but she mentioned the repeat, and there's no repeat on this property. the law is it can apply to different properties. I'm just trying to explain to you the notice issue.
Okay.
Because I would say that maybe the repeat doesn't apply to this property and,
Right.
and that tenant's gone.
I have a question for Ms. Phillips, Mr. Chairman. Ms. Phillips, is it true or not that if you're a repeat violation on one property, you rent others, you're also a repeat on the other properties?
If you own one property and you're found in violation by the board, if you violate that code section again, which is the advertising, it's a repeat violation to all that you own. And that I can appreciate what the attorney is trying to say. However, Muhammad is a grown man. He has 4 properties that are worth $2 million on the beach. Each time he has not come down, and I know you probably don't know all the legalities of the case, but he has definitely been in touch with me and Nicole and has postponed code board hearings. He was going to come, he never showed up. And he did have a representative come from 839, if you remember the young lady named Patricia who sat in the front row with a contract, who said she had a year contract with herself and her husband named Ken, I think it was. And as I started to unravel the case, she got nervous, took her paperwork and left that at that time. So he has had people here. He has admitted to leasing. Whether he knows what's going on at his properties or not, to me, is his responsibility. And as far as notice for somebody who can afford to have 4 properties at the beach and whom's a doctor, I've told him 3 times it's your responsibility to update property appraiser. I cannot do that for you. Our computer system is linked to them. If that's who he has where that mail's going, that's where it's going. If he has one for Tennessee, it's going to Tennessee. If one's Lantana, that's where it's going. I don't have all day to research that for him. That's his responsibility as an owner.
Right. Thank you.
Sure.
And sir, I'd like to mention too, you were talking about the time that the city has spent investigating this. I can't tell you how many cases over the years where the neighbors of these violations came here and told us how their lives were ruined because of the late night parties and the obscenities and the trash and the, so there's another side to that too that you got to consider. To me, the time that they spend is well worth it to the citizens here in this city, And to say that people down there don't know about it, I don't buy that either, because we've been hearing these cases for a long time now, the short term, so.
No, just, if I may just clarify, of course, I didn't say they wasted their time, at all. Again, I live on the beach, I live on that part of the beach.
Right.
Just the time to find this address for Tennessee would have been seconds compared to the time it took to do all that, again, with that. So that was the only thing. No, I mean, I appreciate, I need them to do things because I'm a resident down there. But,
right.
Again, I just believe in equity and fairness. So.
Okay.
So was you've been dealing with Mr. Muhammad for some time now?
2015.
6 years that I know of. Okay. And when you sent the first notice on Lantana, I'm trying to find something about this gentleman, did it go to Lantana or did it go to Tennessee the first time?
The very first notice was sent to 937 Bruce Avenue. I don't have that case with me. The second one was sent to 839 Lantana Avenue, which on his business tax receipt, he had the lady across the street, Kim Patterson, as his representative. When I spoke to her, she said she is no longer his representative, so that's where the mail goes. I can't change property appraiser for him.
That. So then subsequent to what all transpired then, he had the address changed to Tennessee.
He has, I believe, this location at 763. He had time to put that one in the Tennessee, but not the others.
So what I'm trying to say, sir, is he knew about this. He knew that to get proper notification, he needed to have it sent to his Tennessee address, and he did it for one of his properties. He chose not to do it for the other 3. So it isn't like he was not unaware of what he could do. Please.
If I may.
Yes.
The deed for Lantana, it's pre-typed in there, okay? So that is the title company typing the address in there, okay? And that deed's in the public records. This one, there's a blank spot for it. So I know you think he's some rotten person, but that one is pre-typed by the title company, and it's directly to the property address for Lantana. This one, they gave him a space, and he wrote it on there. So he's not this master criminal that wants to defraud the city of Clearwater. He's really just a doctor that's very naive, and if you know doctors, they're great doctors, they make a lot of money. They're really bad business people, you know? And you just don't make smart decisions, you know? And I believe that, and I'm asking you to consider that.
City, have any questions? Mike?
Counsel, I just want to clarify. So this guy, Paul, your client has 4 one-year leases on each of his properties?
No, sir. He has a year lease on, he had a year lease on Lantana, okay, January of 19 to 20. And then he had a year lease on Mandalay, I think the same time period.
With who?
With Paul. The Mandalay is with Paul. The second one, Lantana, has on there Paul, Kenneth, and Patricia, and it's a different last name. Kenneth has the same last name. Patricia has a different last name. So he was under the impression that these two people are renting Lantana, and Paul is renting that, and he had Paul guarantee the lease for Lantana.
He just happened to rent to people who turned around in short term that, that's just what happened to happen?
I mean, he rented it to them, and they, without his knowledge, short-term rented it. I mean, Paul's name is on the Airbnb. He's not doing it. He's not making the money.
All right. Any other questions? I need a first motion.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
You gotta finish it.
Oh, I'm on the wrong page, I'm sorry.
Page 3. There you go.
And has committed a repeat violation.
Second.
All in favor?
Aye.
Opposed? That's carried. Did we hear your recommendation?
Not yet.
Not
No.
yet.
Sir, would you just have a seat one more time, please?
Of course.
And we'll hear from the city.
So my recommendation for repeat violation for case 234-19, there's one violation for repeat illegal short-term rental. I'm requesting $500 per day for the following dates. The first time I saw the advertisement, which was on August 2nd, 2019 for 1 day, and then September 26th through October 22nd for 27 days, totaling 28 days at $500 per day, which totals $14,000. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
What's your date deadline there? The 27 or?
The first time I saw it was on August 2nd, so I'm counting the 1 day instead of August through the 26th, so I'm counting September 26th through October 22nd.
Okay, thank you.
Ms. Phillips, does your office also set the amount of time that the fine is to be paid?
I don't believe we do.
Okay.
Any questions?
We have it in the motion.
Any questions from the board?
I usually go 30 days or 60 days.
City, have any more questions?
Do you want to take out that?
Andy, what's, I give a time.
No, we were just discussing that it's 30 days or the city has the right to record the lien, which they have done in the other cases.
So 30 days is the proper.
I knew that from before, but I just thought maybe it had changed, that's why.
No, that's what it is.
Okay.
All right, well, thank you. Sir, would you come back up one more time?
Thank you, Judy.
We're going to make a second motion. I'd give you an opportunity to say something else if you'd like before we make that motion.
No, thank you.
No, okay. Board, I need a motion to wrap this up. Mike?
I'll make it.
I'd love to.
I don't care
Oh,
who makes it.
Mike wants to go.
I move to enter an order that a fine of $500 per day be imposed for the 28 days of the repeat violation existed, for a total fine of $14,000 payable within 30 days. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Opposed? That's carried. Okay.
Excellent, thank you so much.
You're welcome.
Thank you, Council.
4.13, case 236-19, find the respondents Nicholas Bay Tenney at 1335 Milton Street in violation of code for permits and issue an order with the compliance. Did I miss one?
Yeah, 4.12.
Excuse me. I apologize. 4.12, case 235-19, find respondents Brian Bennett at 2117 Campus Drive in violation of code for permits and issue an order with the compliance deadline and fine if compliance is not met. Are they here? Oh, hey. Would you tell us your name for the
Yeah.
record, please?
Brian Bennett?
Brian, have you been sworn in?
Yes.
And Brian, do you admit or deny?
Admit.
You admit. Brian, if you'd have a seat in the front row, we'll bring you back up. I need a motion for the admit.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? That's carried. And Inspector Switten?
Yes. Yes, good afternoon, Board. This is case number 235-19, 2117 Campus Drive. There's one violation at this property, two sections, section 4-203A.1 and section 47.083, section 2. Notice of violation was sent out, certified and regular mail, on August 23rd, 2019. Certified mail receipt was on August 29, 2019. Notice of hearing was also sent out on certified and regular mail, October the 4th, 2019, and the certified receipt was received October 22nd, 2019. This property is located just south of Druid Road, west of Belcher. And this is an area view from Google Map showing the top of the property home, and in the right corner there in the backyard you can see a small shed. So another view of that shed area. This photo was taken on July 10th of 2019. You can actually see a very large structure that's being constructed during that date. This is from the front of the property. This is another shot.
Is it raining?
This is also showing a better shot of the structure on July 10th of 2019. Some more photos here. On November the 12th of 2019, I went back out to the property to take another photo, and the photo is now showing that the roof is completed, and if you noticed in the previous picture, the structure itself has been completely turned. And if I can, just in case you didn't see it, you can see the rafters here facing one way. Now the structure is completely turned.
Why?
That's the same angle?
This is the picture from the same shot.
Yeah.
And I'll give you this is from the side street off of campus. Now you can see the garage door. Of course, this is the finished product of this particular property.
Okay.
So how are you made aware of this?
This came in as a unanimous complaint.
Okay.
What's anonymous complaint, like a neighbor?
I'm assuming.
Yeah,
Wild guess there.
Whistleblower?
There you go.
A whistleblower.
Whistleblower.
Found
We did a first admit, right?
Yes.
Yes.
We did.
Oh, we did. Yeah. Okay, Mr. Swinton, thank you. Sir? So you see what the city presented to us, what do you have to say?
I don't. I just did not obtain a permit for the shed. I tore down the old one. It was rotten, termites, whatever, so I needed a storage.
Right.
So I did build a shed, and between getting the notices, the final notice that he had sent, where the thing was still under construction, we had completed the construction of it before I got that final notice for the third notice for the hearing. So at the point where I had gotten all that, I had been in trying to talk to the building permit people to find out exactly what all I needed to do. So the shed, I turned it because I was getting it ready to get it off the setbacks. I pulled it off the setback so it wasn't in violation of that. And I've just been trying to get the engineer to get my drawings all approved and stamped like I need to pull a permit. So I finally got that done. I actually went and pulled the permit, or started the process this morning.
Good.
So it's in to be permitted.
Okay.
So I'm trying to get it in compliance. It's just,
I'm curious, how many square feet is your shed?
it's 12 by 14.
12 by 14?
It looks a whole lot bigger than that. I mean,
What's that, 144?
12 by 12 would be 100.
No, more.
yeah, it's like 160,
Yeah.
something like that.
Is this so this is an existing, right? Your shed, does it have a footer? Is it permanently on the ground?
No, it's on a wood skid frame, like a prefab shed would be. I originally put it on a slab because I didn't want issues with termites and stuff. So once I realized that was going to be a problem, I jacked it up, put the floor under it, and I'll do away with the slab.
Okay. I don't know what the codes are. I thought if it was under a certain amount, you could do that without a permit, but
It's
I could be
100
wrong.
square
Don't listen
feet,
to me.
then I don't have to have a permit,
There you go.
obviously, or evidently. So,
Okay, well, it sounds like you're on the right track. You know who to communicate with now.
yeah, it's just been ongoing process, trying to deal with an engineer to get something
Yeah,
done
Looks like you did a good job.
Did they give you any indication how long it would take to process your permit request?
He said with the holiday, it could be like maybe 2 weeks to get it through. So,
We got to hear his recommendations, so.
I have one question for Mr. Bennett. I have to ask this, Mr. Bennett. Why didn't you investigate to start with that you needed a permit?
probably just old-fashioned stubborn. If you want something on your property, build it and get it done.
But you knew deep down inside you're supposed to have a permit.
Well, I didn't know I had to have a permit for a shed
Okay,
until I got a notice, and then I'm like, oh, well, okay.
okay.
So I did try and contact them and I was trying to get all the things I needed. How big can it be? How does it have to be built? So, I mean, it took a while to get all those answers, but once I got them, I've been getting the thing under compliance, and
So
now
you
just.
thought for that 12 or 14, you didn't really need a permit then?
What's that?
Was that your thinking, you didn't need a permit?
Yeah, I mean, I've lived other places, lots of places, and we didn't need permits, unless it was a big structure, like part of a house or something, so.
Well,
it was.
Clearwater, we have our own codes.
I found that out.
Okay, Brian, if you'd have a seat, we're going to
Thank
bring
you.
it back, and Mr. Swinton, we'll hear what the city recommends.
Okay, for compliance to be met without a permit, you have to obtain all required building permits and schedule all required inspections. Recommendation is for case 2235-19, requesting compliance on it before December the 20th, 2019, or a fine of $150 per day per violation for each day the fine continues to exist. We are also asking the board to authorize the following. After 3 months from the recordation date of the such lien, If the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
Okay, sir. Thank you very much.
Sir.
Brian? Brian, he mentioned about the holidays. I would be willing to extend it into January, seeing we are in the holidays.
If I could, that would be great, because
Yeah,
I'd like to
you've
say,
been-
yeah,
you've
it'll be
been,
done, but as sure as I say that, I won't get
Yeah.
my permit for 3 weeks, and then I got a week to get it all
I'm
done.
okay with
You don't have any
that.
control anymore, you've lost control.
Well, that we can help you with.
Yeah, we can help you with that, and I appreciate your honesty.
The city would be okay with going into January? They don't have a big issue with that?
That would be fine, but it won't take 2 weeks.
Good, okay.
If everything in his submittal is good.
And if is always the
We don't have
problem.
any
Yeah.
comments about the placement of the shed.
Well, he said he'd appreciate it, so.
Okay.
All right, thank you. Let's close this one out.
Okay. I moved on an order requiring respondent to correct the violations on or before January 20th, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. Fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
All in favor? Opposed? That's carried.
But you need to stay in contact with Mr. Swinton as you make progress on this.
Right.
Even though they're in the same building, they don't talk.
All right, Brian.
So is that, just for clarification, if everything, does that mean everything has to be inspected, complete?
You have it's approved,
It's
yeah.
all approved and
Right.
everything's finished by January 20th?
If the permit is active, the stop work order goes away.
Okay.
Okay, good.
Okay.
We don't want to see you back here.
I don't want you to either.
Thanks, Brian.
Just work with them on it.
Right, 4.13, case 236-19, fine respondents Nicholas Bay Tenney at 1335 Milton Street in violation of code for permits and issue an order with the compliance deadline and fine if compliance is not met. Are they here?
Not here.
No? Is this a declaration?
No.
No, so I need a admit.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? Inspector Swinton.
For compliance to be met on this particular property, get everything started here.
This is another one without a permit.
Yes, sir. This is 1335 Milton, case 236-19. There is only one violation against section 4-203A.1 and also section 47.083, section 2. We did send out the notice of violation certified in regular mail August the 7th of 2019. And certified mail receipt August 16th, 2019. Notice of hearing was sent certified regular mail October the 8th of 2019, and that receipt was October the 22nd, 2019. This property is located just between Lakeview, east of Missouri Avenue. And it's a fence that was installed, wood fence. This is a picture from February the 20th of 2019, when we first got notice of the violation. The fence encompasses the entire property, which is a pretty large parcel. More pictures here. So again, in March of 2019, March of 2019, I posted the property in April of 2019. This posting was the initial posting for the previous owner that was still in the property appraiser. However, the property was purchased in December of 2018, but did not change on the property tax receipt for some reason, I don't know. Again, in April the 29th, 2019, the fence is still there, no permit issued. And this picture was taken on November the 12th. You can see that the fence is still up, no active permit. November the 12th also, November the 12th.
So how many homes are on that property?
It's only one home, but it's a very large parcel. It also has a mobile home, a mobile RV
Yeah,
on there.
okay.
Inspector, in the city of Clearwater, when you put up a wood fence like that, is it true that the finished side has to face out?
That is correct.
That's correct, huh? And yet you drive around, you see it the other way all over the place. You know, the ribbed or the support side is,
Yes.
they did the finish side facing there, you know?
Correct.
Any questions? You might as well tell us your recommendation.
In recommendation in case 236.
Oh,
I'm sorry.
Mr. Swinton, I'm sorry, yeah, I need a first motion.
I move to find respondent in violation of the code.
We had one.
We had-
Sorry.
we did?
Oh, we did,
Oh, I'm
yeah.
sorry.
Yeah, we did. I always underline it when I write it down, because I don't, you know.
Okay, that's fine.
I'm sorry, go ahead.
Okay. Recommendation case 236-19, request compliance on or before December 20th, 2019, or a fine of $150 per day per violation for each day the violation continues to exist. We are also asking the board to authorize the following after 3 months from the recordation date of such lien. If the fines and fees remain unpaid, city attorney's office authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
And what do they need to do to, okay, there you are.
And for compliance to be met, without the permit, obtain all required building permits and schedule all required inspections.
What was the date on that one again?
12/20.
The 20th?
Any questions for the inspector? Make a motion to close it out.
I move to enter an order requiring the respondent to correct the violations on or before December the 20th, 2019. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day. Each violation continues to exist, one violation. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
I need a second.
Second.
All in favor?
Aye.
Opposed? That's carried. Thank you, Mr. Swinton. 4.14 is withdrawn. 4.15, case 238-19, find respondents, U.S. Bank National Association as trustee for Greenpoint Mortgage Funding Trust Mortgage Pass-Through Certificates, Series 2006-AR8 at 904.5 Turner Street, in violation of code for unsafe building, and issue an order with a compliance deadline and fine if compliance is not met. Are they here?
Well, that's a mouthful.
Declaration?
No, sir.
So this would be an admit.
Yes.
Mr. Chairman, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? Inspector Cantrell.
Lay it on us.
Jason Cantrell, presenting the case for 904.5 Turner Street. This property is in between Myrtle and MLK, just south of Chestnut. I just wanted to show you a couple photos real quick. This property caught fire some years ago. This did come before the board at one time and was found in violation. And then after that, the property was foreclosed on by the bank, and per legal, we decided to come forward again and ask for another order. So this photo is from 2018. See, it was a pretty bad fire.
I remember that case, yeah.
This is in 2019. This was on the 14th of this month.
It's been standing in this condition for how long?
Since 18.
Well, since I brought it the first time, yes. But prior to that, I believe the fire was in 2015. I think was when the actual fire was.
So the trustee is Greenpoint Mortgage Funding Trust Mortgage Pass-Through Certificates. I mean, they own it, right?
Mm-hmm. Correct.
Why aren't they here?
They hired a property manager who assured me that they were going to get the property into compliance.
When did he assure you?
When?
Yeah, when did they do that?
It was about 4 weeks ago, I'd say.
Okay.
They assured you, but they just didn't say when.
Right.
They left the flag on it.
They did.
Supposed to take the flag off.
Yeah.
Respect it, you know. Anything else you want to tell us? Police reports, neighbor complaints?
I've had complaints from neighbors. I did not pull up any police reports.
Power's off, water's off.
Yes.
Yeah, not to mention it's a public hazard.
It is.
Jeez.
It's open to
Yeah.
anybody that.
So why don't you tell us your recommendation?
Okay, the city's recommendation for compliance to be met by, for the unsafe structure, repair or replace any areas where deterioration or damage exists to meet current Florida building codes. Complete demolition of the structure is also an option for compliance. All work must be properly permitted. And we are requesting compliance on or before December 20th, 2019, or a fine of $150 per day that the violation continues to exist. Additionally, we are asking the board to authorize the city of Clearwater to enter onto the property to correct the violations by any means necessary and any reasonable cost to be applied as liens against the property. After 3 months from the recordation date of such lien, that the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
So I have a question.
Yes, sir.
$150 a day is not a lot of motivation for these people, but how quickly would, in past history, has the city moved on something like this? You know, I can see the 20th, December 20th being a reasonable date for them to respond to it.
We will begin moving immediately after the affidavit
Okay.
of non-compliance, so it is a long process.
So I don't think that the $150 a day increasing is going to motivate them anymore one way or the other.
That's entirely up to you.
Yeah.
You know, it's more than an unsafe building, you know? I mean, if you live next door to that thing and if the wind is blowing right, you know, that burnt wood is like toxic, you know?
There are actually two buildings on that property with two separate addresses, and it's a multi-family unit in the front that has to live around that.
Oh, yeah.
Yeah.
Got it. That's amazing. All right, so I need a first motion on the unsafe.
Yes, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? You told us your recommendations. Any other questions for the inspector? If not, we'll move on to the second motion.
Second. Go ahead and do
I move to enter an order requiring the respondent to correct the violations on or before December 20th, 2019. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation. For each day, each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
We need to
You need to be on
read
page
the
4.
unsafe building.
The wrong one?
Yeah,
Four.
read page 4.
Oh, sure, you did such a good job reading.
Yes,
Take it.
it's different. Yeah, read that.
The second one.
The second.
Oh, that one, okay. I move to enter an order requiring the respondent to correct the violations on or before December 20th, 2020. If the respondent does not comply by that date, the board may... 2019, I'm sorry, thank you.
Okay.
That's okay.
Take your
If the
Take your time.
respondent does not comply by that date, the board may order a fine of $150 per day for each day the violation continues to exist, and the city may take all reasonable actions, including entry onto the property, to bring the property into compliance and charge the respondent with all costs, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
And I'll second that one.
All in favor?
Aye.
Opposed?
I think it was...
That's carried.
Good job, Sheila.
No, I can read.
I like when we zero in on these. I feel like we're
Yeah.
doing our job, you know what I mean?
Yeah.
A 4.16, case 254-19, find respondents Ruth M. Cirola at 1100 South Myrtle Avenue in violation of code for unsafe building and issue an order with compliance deadline and fine if compliance is not met. Are they here?
Yeah.
Hi.
You read real good, Sheila.
Hi, would you tell us your name for the record, please?
My name is Renee Russell.
And ma'am, were you sworn in?
Yes.
You were, okay, good. I remember you guys, you were here last.
I was by myself. This is
Yeah.
my son,
Ah.
Brian.
I was not sworn
He
in.
looks just like you.
No, he's handsomer.
Were you sworn in?
I did not raise my hand. Can I do that now?
Yes.
Do you
Yes,
swear
sir.
or affirm to tell the truth throughout your entire testimony? Thank you.
I believe this was the property down, down on Myrtle down.
Yeah.
Right. So do you admit or deny?
Since I was here on the 25th, I can't see, of September,
Right.
and you gave me until the 23rd of November to try to fix the abandoned building, the exterior surface, and the roof maintenance. And I explained to you that my wish, that the property's been up for sale.
Right, I remember that, right.
Ruthie passed away a year ago, July 19th.
Right.
And I'm her best friend for all these many, many years.
Admitted at this point, right?
And we did change realtors. And I've explained to the board at the time that I don't have the money for demolition. And these old buildings,
I remember that. So it's still non-compliant, right?
have not,
And you say the city gave you till the 23rd of November?
I believe you did, sir.
I'm sorry?
You did.
Yes, sir. You said
We
a
did.
couple of.
Yeah, the
So,
book. Yeah,
and-
no,
and-
just,
yeah.
all you gotta do is say yes, so, okay.
And, Mr. Chairman, and at that meeting, Mr. Cantrell said that they would be bringing this action forward also. So, I mean, that was the city's plan at that point, to have it declared unsafe, I believe, and go forward, so.
Okay, so here we are today. It's not the 23rd yet,
Almost.
almost.
Well, because I received way before that I had to be here on the 23rd. I have an older letter that I had to be here on the 23rd of this date. And even when I was here in September, I knew that I had to come back on the 23rd, even though you gave me, on the 20th, even though I knew that you gave me until the 23rd.
May I, so I think what we're hoping is for some sort of hardship consideration, considering the
Okay.
situation.
Hey, can I just stop you for a second?
Of course. yeah.
I have a question.
Yes.
Andy, I'm reading your mind.
Well, we're doing it. No, go ahead.
She has to the 23rd.
Yes,
Today's the 20th.
yes.
So
This is a
what's up with that?
I can show you the letter.
That's okay, you don't have to say that.
Oh, Mr. Chairman, if I remember correctly.
This is a different violation.
Right.
Oh,
Okay.
oh,
But
excuse me.
So, if I remember correctly, Mr. Cantrell said this action was going to take place, okay? We encouraged your mother to maybe consider an equity loan instead of her trying to lay the money out of her own personal thing, because she's the executor of the estate and to get some assistance, okay? So, we know that she's doing everything possible and so forth, so that I'll shut up.
Gotcha. And we discussed that.
Excuse me, what is your name?
Ryan Stanley.
Ryan Stanley?
So when you were before us the first time, 2 months ago, was that unsafe building then?
No.
No?
Oh,
So that's why this is a different case?
Correct.
Because it's before us now, it's unsafe.
That was brought by Inspector Greg.
Okay.
I have I keep pointing to my notes over there. When I was here before, Mr. Greg Dixon showed you pictures of how the property has been cleaned, all the brush, all that code has been satisfied. The only other are these three: the abandoned building, exterior surfaces, and the roof maintenance. Thank you. The old building behind the front building has been there for many, many years. It was Ruthie's dad's warehouse for his produce.
You know, just so I have my
It's been that way many, many,
thoughts
many
correct, you have till the 23rd on those 3 violations. But now you're here today because it's moved into an unsafe building.
No, it was considered
Am I correct in that?
I'm sorry, I did not hear.
Was it an unsafe building at that time, you're saying?
Those violations that she had 2 months ago that we, the
It's
board,
still-
gave her, abandoned building, exterior surfaces maybe, and whatever.
If I chose-
And roof.
We gave her to the 23rd to comply.
because it was considered unsafe.
Right.
And I agreed.
But it wasn't unsafe then, was it?
The
Yes.
city brought it against violations, the roof was deteriorating and all that stuff. It
Right.
was Castman that had that.
I had cited
It was
the property
unsafe.
prior to that board hearing. However, the notices and stuff hadn't gone through, so I wasn't prepared to bring it forward as unsafe. So it didn't receive a declaration as unsafe.
So it's before us today is unsafe.
Today is for unsafe, correct?
We're not talking about September's.
Right.
This is different altogether, yeah.
Yeah, so
Different charges.
are you on page with that, ma'am? You're not here because of what we told you or what we ordered you to do by the 23rd of November back in September. We're here for a different case entirely,
Correct.
unsafe.
Correct.
Thank you.
Okay.
Okay,
Can I show you the letter that
You guys good with
will
that?
be here on the 20th?
Yeah, makes sense.
It's the same property, does she understand it's the same property? The property hasn't
oh yeah,
changed.
no, same
By
property.
formally
Same
notifying.
everything.
It's progressed to a different scale.
Why don't, instead of,
I
why
don't
don't
think
we
that's
just
clear to-
continue this Inspector Cantrell's case
Right.
to a date after the
That's what-
compliance date?
I was gonna say the same thing.
But meantime,
Then we
And I'll
can,
give the gentle lady time to either fix it up, or if not,
They should be able to at least do the exterior surface, that's not an issue. The question is whether or not they're going to be able to sell it or fix the roof or have somebody who's going to demolish it if they buy it. That's what they're in the process of determining.
I explained to you that we've never planned, have no reason to remodel these two old buildings. They are old.
we understand that.
1,020, 80 square feet. One was Ruthie rented for 17 years after her dad died 24 years ago as a Mexican restaurant.
Okay,
They've been out since June because the building, it's leaking and I said, it's no longer safe.
What is it that you would like
More time
to do
to
what?
sell. We have a new realtor
okay.
with a bigger team. And I'm just,
It was listed with a personal friend who was a realtor before, who was
Right.
residential. I mean, it wasn't his expertise.
I think the city just agreed that they would postpone this to a future.
Continue it next
Okay.
month.
They're working it out now.
Yeah, well,
I think you're on it.
so we'll move to.
Don't worry,
Alright,
dear,
so
it's
we're
gonna be
gonna
all
just
right.
continue.
It's gonna be all right.
Mike, what did you say? You said the city would be willing to,
Well, I think that we could continue this case, if the compliance date's November 23rd,
right,
that's probably not gonna comply with it, but why don't we just continue it to next month, to December? And then and then we could come back next month and we could see where they're at.
Right, we could basically set it for a status at that point. We've done that in the past.
okay. Andy,
They know what we expect for them to start
And
doing
they're-
and work
and they're-
on, so.
Right, they're moving
We're gonna
forward
be
to doing
as
those
fair as we
things.
sell it. I said,
Right, if they can sell it or,
Right,
but
okay.
at least they can do the exterior aspect of it to take that off the table.
Yeah, that'll be gone.
The exterior pressure washing and painting the building won't be a big expense.
Yeah.
A roof-
so the language on that, Andy, from the board would be,
Just to move it, to reset it for next month for status.
okay, we could, unless we have any other questions. Is the city okay with that?
That's fine.
Let's
I'll make a motion.
Okay.
I move that case number 254-19 be continued to the December meeting, 2019.
Second.
All in favor?
Aye.
Opposed? We'll see you next month.
Thank you.
You're welcome.
thank you.
You're welcome.
Give you
It'll
some
work
time.
out. It'll work out.
4.17, continued from September 25th, 2019 to December 18, 2019. 4.18, withdrawn. 4.19, case 256-19, find respondents, Rutledge Revocable Trust, UTD, 42897 at 1115 North Martin Luther King Jr. Avenue in violation of code for unsafe building, and issue an order with a compliance deadline and fine if compliance is not met. Are they here?
They are not.
Declaration?
Correct.
Hey, we can handle that. Yeah, declaration.
I move the finding respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed.
No, I'm sorry. I said declaration. It is not a declaration.
I didn't think so.
I apologize.
Okay.
Okay, so they're not here, it's a first
They're
amendment?
not here. It is, yes, it needs
Hey,
to be.
First violation?
There's no
I
surprise.
move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Opposed? Inspector Cantrell.
That would explain the look I was getting from my boss over here. Okay, this is the property at 1115 North Martin Luther King Jr. Avenue. I just wanted to show you a couple of photos real quick before I go to recommendation. This property is on the east side of North MLK, just north of Palmetto. This is the front of the building. This is the north side of the building off of LaSalle, and that arrow is pointing to the area of concern.
Concave roof.
Yes. This is an unsafe canopy that was falling down. This was what originally brought our attention to it. It has since been removed. A permit was not pulled to remove it, which would require one, but that section is gone now. That's just showing by posting, the unsafe posting. This is after they removed that canopy portion.
Better already.
And this was this week on, just showing the roof is still in the same condition. They do have a roofing permit pulled, however, nothing has been done at this time.
When did they pull it?
I don't recall the date.
I mean, recently or?
A couple of months ago.
Couple months.
So the unsafe portion was just the overhang?
No,
And
the
the roof.
And the roof?
Yeah.
So they're gonna salvage that? I mean, they pulled a permit.
They're going to try to.
So they pulled the permit to re-roof, and that's the roof covering. The issue is the structural portion of the roof.
Right, exactly.
Yeah, that's gonna have to be rebuilt.
Do you have pictures of the inside?
I do not.
Well, and they did apply for a permit.
For the re-roof, yes.
Are you gonna give it to them?
Just the re-roof, yeah.
Oh, they were approved for that.
Oh, they were approved for that,
The issue which,
but not the structure.
right, which wouldn't be covered under a roofer's.
That looks like it needs structure work.
Yeah, correct.
That's why I asked if you issued a permit for the roof.
No, not for the structural. Nothing has been applied for
Right.
those repairs.
These, some people, they'll replace that roof and then they'll never call in that inspection.
Mm-hmm.
You know how that is.
I do.
Or the roof over the unsafe structure.
Yeah, be nice to see up, see the rafters.
Yeah, unfortunately, it,
What, neighbor complaints?
I believe it was neighbor complaints that went through, Code Inspector Jewett, and he let me know about the property.
I love when they come in and talk to us,
Yeah.
What's your recommendation?
For compliance to be met for the unsafe structure, repair or replace any areas where deterioration or damage exists to meet current Florida building codes. Complete demolition of the structure is also an option for compliance, and all work must be properly permitted. City is requesting compliance on or before December 20th, 2019, or a fine of $150 per day that the violation continues to exist. Additionally, we are asking the board to authorize the City of Clearwater to enter onto the property to correct the violations by any means necessary and any reasonable cost to be applied as liens against the property. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
Okay, any questions for the inspector? Let's make a motion. Second motion under the unsafe.
I move to enter an order requiring the respondent to correct the violations on or before December 20th, 2019. If the respondent does not comply by that date, the board may order a fine of $150 per day for each day the violation continues to exist, and the city may take all reasonable actions, including entry onto the property to bring the property into compliance and charge the respondent with all costs, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, settle, or collect such lien.
Second.
All in favor?
Aye.
Opposed? That's carried. Thank you, Inspector. 5, unfinished business. 5.1, accept the affidavits of compliance as listed.
Move to accept?
Is anybody here for that?
No, not for me, these are,
Okay.
they're good.
Oh, okay, we're good. There was a motion to accept.
There was a second here, sir.
All in favor?
Aye.
Opposed? That's carried. So where does that take us down to?
Other board action on page 6, I think.
Affidavits of non-compliance.
9.2 on page.
Well, you had a lot of those, huh?
Page
Page
6.
6. Accept affidavit, they're all.
These are the non-compliance.
They're all non-compliant.
Where's the non-compliance start?
Starting 5.2.
Gotcha. 5.2, continued from October 23rd, 2019, case 106-119, accept the affidavits of noncompliance for respondents Jonathan P. Grinstead at 48 Midway Island for permits.
He needs to be sworn in.
Were you sworn in?
No, we were not.
Do you swear or affirm to tell the truth throughout your entire testimony?
Yes, I do.
And this is to accept affidavits of noncompliance. So what do you have to say?
I've actually spoken with the gentleman in this council, and what we have agreed to do pending the board's approval is to continue this affidavit of noncompliance for one more month. I want to be clear. The gentleman has, as the board may remember, this is the case with the pool. And the gentleman has removed everything and planted sod. The issue there was that that work needed to be done with the permit, a demo permit, and it wasn't. So what I've spoken with this council and with the gentleman about is we'll agree to continue this to next month. If in 1 week's time, the gentleman is able to apply for and obtain an after-the-fact demo permit, then what we will do, the city will do, is withdraw the affidavit of non-compliance, just issue an affidavit of compliance, and the case will be over. On the other hand, and I wasn't as clear with this last month as I thought I was, if that doesn't happen, when we come back next month, we're going to ask for the board to accept the affidavit of non-compliance and start issuing fines retroactive to the compliance date, which was September 1. And we can argue about whether it's in compliance or whatnot, but I just want to be clear that we understand what I'm saying here. Was that we'll continue it. If a building permit is applied for and obtained in a week, we withdraw the affidavit of non-compliance, affidavit of compliance is issued, case goes away. If not, we'll come back next month and we'll ask for fines.
That month be 1 month from today, December 20th?
Is that when our meeting is?
Or our next meeting?
Depends on when the next meeting is.
The next meeting is when?
18th, yeah.
Oh, it's early.
December 18th.
Right,
Yeah.
so it'll be okay.
Okay, well, and so we're clear, I mean, next week is a holiday, so you want to give them 2 weeks?
Yeah.
We'll give 2 weeks to apply for and obtain the permit, so that will be, the 20.
We just need to, no, our motion will only be just to continue it to next month.
Right.
Whatever you all do internally is up to you.
Yeah, we're just gonna make a motion to continue it out a month. What you do with your 2 weeks, yeah.
Right.
Make a motion. Okay, I move that case 106-19 be continued to the December meeting.
Second.
All in favor?
Aye.
Opposed?
Aye.
Okay, guys.
I have a quick question regarding, so the last time you were here, we saw all that beautiful work you did, and obviously the problem, it was gorgeous, we all knew that. The issue that we had, that it wasn't permitted work, right? How did we then get to this, so we told you to tear all that beautiful work out, but then there was nobody walked you through the process of what needed to be done as far as a permit to tear it out?
Well,
How you got to the, because this is.
because I was told that I needed to be compliant and I needed
I'm
to
sorry, you
take it
didn't
back.
tell us. What is your name?
Lance Hidalgo, ma'am.
Hidalgo.
Hidalgo, first name Lance. Through the previous meetings that we've had several times.
I thought you had applied for a permit.
I applied for, there were two separate entities. There was
You had to get
first-
that reversed
I got all the
retro
engineering, and
done.
then I went and I had to apply for the permit, and I wasn't getting anywhere, so I went and met and asked to speak with Miss Ellen Crandall. And she reviewed all my notes and everything I had, and basically said that there is no such thing as a hardship regardless of your engineering, everything that I had in place. And, you know, if you're not compliant by the 20th, you know, and make it back to what it originally was, then there's nothing I can do for you. Which I was under the impression I was going to be fined $15,000. So I had already, all the steps that were there were still there. I just went over them. So I just had to remove 40 tons of base and pavers and everything, and got it done. So yeah, it was a lot of work. But now I already have everything ready now that I need a demo permit. I already have all the new the ISR numbers, everything showing that it's back to normal, just from like the original in '97. And I'm gonna go tomorrow morning, because I know what time the building department closes, and apply for the demo permit tomorrow.
So,
Sorry you had to go through that. My question is why we didn't hold your hand and almost walk you through that process of saying, you need to tear all this beautiful work out that you did, dump it, throw it away, but why at that point did nobody say, but you need a permit for this and here's how you do it, or here, make sure you do that? It's just, it seems like it puts you in a pretty bad position of time and money.
I didn't want to take a chance, honestly, and this is what I told Mr. Owino. I just, after meeting with Ellen and after getting all the engineering in and not getting any feedback of, because the permit was sitting there that I applied for 6, 7, I don't remember exactly, but a couple months. And I wasn't getting notes back, and basically once I got all the proper engineering and took it down there, another 7 to 10 days went by and I didn't hear anything. So I made it a point to go there and ask to speak to the head official and show her everything, and you know, like, what are my chances on this being approved? And she basically just said there is no such thing as a hardship. You're within that 5-foot setback regardless of the engineering and everything. So at that point, I wasn't about to take a chance and come in here and get fined and then have to try to fix it. I'm getting married next week in Buffalo, so I figured just rip it out, and it is what it is. Make everyone happy, be done with it, and just put this nightmare behind me.
and when all's said and done, you still don't own that house.
No.
You still,
No. I'm gonna buy it, but I bought the showroom at 110 Island Way, and that was the money down to buy that. So I'm just renting from Jonathan Grinstead, who lives in Boone. We're like family, and I told him I would take care of all this, and I know.
I would vote for you.
That was a huge waste of
Case
money.
of the year, I'm just telling you.
Well, congratulations
Well, good luck
on
to
your
you.
marriage.
Can I ask you a question before we lose you? But you just bought what on Island Way?
Oh, I own 110 Island Way. That used to be the Island Way Realty, yeah, with Michelle Chanel.
Yeah.
So I own that now for Island Way Pools.
That's very nice, that
And then we have
building.
tenants in it.
Commercial building.
Why are you getting married in Buffalo?
Her father has dementia, and we've been engaged 2 years, and I think we need to do it kind of quickly.
Good for you.
I want him, yeah, so he can walk her down the aisle at the house.
Well, good luck.
Thank you, sir.
You're welcome.
Thank you.
Thank you.
Let's make any other questions?
No, we didn't. We're good.
Oh, we did, we're good.
We moved it.
Okay.
Thank you very much.
Congratulations, have a nice wedding.
Thank you, I appreciate your time.
5.3, case has been withdrawn, case 112-19. 5.4, continued from October 23rd, 2019, case 114-19, accept the affidavits of noncompliance for respondents, James Holster, Lynn Hippie, Linda Crotty, Brianna Crotty, Anton Bosek, and Lori Busek at 509 Cedar Street and 912 North Garden Avenue for exterior surfaces, doors, windows, openings, abandoned building, and window maintenance. That's a lot.
It is a lot, yeah.
I remember that case. They're not here, are they?
Yes,
Oh,
he's there. Yeah,
excuse
yeah.
me.
That's that gentleman right there.
Excuse,
the
and you've
family
been waiting all this time.
representative.
I'm sorry you had to wait this time.
Were you sworn in, sir?
Yes, I was.
I know he's been sitting here because he's in my view, you know. So,
I have here your waiting. Yeah.
so this is a affidavit of noncompliance. What do you have to say?
What is your name first?
I'm sorry,
Your name?
Anton Bosick.
Thank you.
Anton, okay, I see your name in there. And you're representing the others?
Yes,
Yes, this was a property that we were acquired from my deceased father-in-law, and was, anyway. So I obtained, after the last hearing, I went to my brother-in-law's and sister and sister-in-law and wife, and we decided that that's what we were gonna do, is we were gonna tear it down. I went to the city, asked them what it would take to get the demo permit, and they said the length of time would be about 4 to 5 days. So after that, then I went out of town for a few days and then came back, and then I went to apply for it. At that time, they told me, as an owner, since it wasn't my primary residence, I wasn't allowed to pull it as a homeowner's permit to demo the property. So I'm also a general contractor, so then I had to go through the process, which I wasn't registered in the city of Clearwater. So I registered my license and then I applied for the permit. I have everything applied for with the county. It just hasn't been issued because I do not have the sewer cap permit, so they will not issue that. And they said I think the engineering is still reviewing the application and should be done in the next couple days. So with that, I told them I didn't get the sewer cap because there's a tenant in 509. And I didn't know how long that permit would be good for, to where if I got the sewer cap right away, how long that would be. And the tenant that is in one of the properties, one of the buildings that's going to be torn down, he's going to move at the end of the year. So everything is in process, they just haven't been issued.
Okay. I understand what you just said. Yeah.
Okay.
Yeah, I'm sorry you couldn't do it in the beginning. Yeah.
Been through it, haven't you?
So you need more time? Is that where we are?
Yeah.
Wait till I can speak.
So there's not a permit pull because they're hauling you on the cap of the sewer?
Well,
right? The demo permit is not.
That won't be issued until that. I'm not saying that I'm not saying that the city is holding up the permit. They won't issue it.
I didn't mean to say they were holding it. That's just the only thing in the way.
I don't want to blame the city because that's not.
Yeah, go ahead.
Oh, thanks.
Yep. Let her have the podium, and then we'll bring you back up.
Hi, Inspection Specialist Julie Phillips. I'm actually presenting for Greg Dixon while he's away. I just want to recap the events that have taken place on this property, and I do appreciate that he came in and filled out a permit for a demo permit. But as a reminder, in April 2015, this property was sent a notice of violation for an abandoned building exterior surfaces and window maintenance and doors and windows. On May 31st, they did an affidavit of posting because there wasn't a certified mail receipt. Then it was July 24th, the property came to the code board, it was found in violation. And August 31st, we gave him that to comply or at least apply for a demo permit. Now September 4th, we issued affidavits of non-compliance. That's when the owner came in last month to the code board to contest the affidavits of non-compliance. So I can appreciate that we want to keep giving more time. I'm just saying right now, the last time he was at code board was at October 23rd. He applied for a demo permit a week after that date, not clear back to April. And yes, he did apply for a demo permit. It was not issued because a certified plumber has to actually come in and get the permit for the sewer cap. And that hasn't been done, so you won't get the permit for the demo till that's done first. But then when I talked to this gentleman, he says, well, I still have a tenant, so what's the hurry? So I guess for me, standing up for my inspector, I would like to say if we're going to give more time, let's hold him to that time, or I recommend going back to the affidavits of non-compliance and getting a fine, because we can't just keep going and going and going and going. Okay. And that's just what I wanted to say.
I remember that was the issue last time, the sewer cap.
I did.
Yeah.
Thank you.
Thank you, sir.
Thank you.
Mr. Chair, may I ask the gentleman some questions?
Of course, go right ahead.
And sir, after last month's hearing, you, your wife, and the other heirs deeded this property into Holster LLC, is that correct?
That's what we were doing, yes.
Okay. And the sole member of that is your wife, Lori?
Sole member of the LLC? No, the brother and the other sister, they'll be on that.
Why?
On the LLC.
So, the point is that you all no longer individually own the property. The LLC owns it.
Is it registered in that now? Because as of last time, it was not registered. We hired an attorney. The property, we just acquired the property out of probation. And so we didn't own the property when most of all of that other stuff had occurred. So what the probation attorney did was he wound up putting the property in the 3 kids' names and all of their beneficiaries, so he did it all wrong. So that's why we had to then have it put into the LLC. So that was, unfortunately, we did not know that.
So I remember some of this case, and Mr. Chairman, and one of the things that you said was that some of the windows have been boarded up, and, well, when you got it was boarded up. He didn't know. So what we have in front of us is a learning situation, and I think you're learning a lot about it. And then to get the permits, I mean, when people come in here and we say they're gonna get a permit, and in 2 weeks, we give them 2 weeks to get it, it doesn't happen that way, okay? That permit department sometimes moves quickly, sometimes it's complicated. So I think we have now something, Mr. Bosick wants to do something about it, and his other family members. Let's just get it done, give them the time. There's no life-threatening issues here compared to some of the stuff that we saw earlier, that house that Mr. Clayton had. I mean, it's horrible. So just give them time and get it done. But at the same time, you need to get it done, and I think your request for putting some fines on the thing to get it done makes sense, and then everybody, both sides feel insured.
Yeah, I agree. You and the others here, you're either dragging your feet, or you're just taking way too long, or you're trying to take the city and us for granted. This has gone on way too long. You know, when you're told to get a permit, you ought to get down there the next day and get that permit, not a week later, and this and that. And you gotta take this serious.
After the meeting of last month, within 3 days, I was down there, and then that's when I asked to get the information of I got the application and all of that, and then she gave me the time frame. Then when I went back to go file for it, that's when she told me that I could not file it as a homeowner. It wasn't that I didn't do anything.
There was a week, you said you went away for a week.
Well, yeah.
You know, so,
Well,
that's why I say you gotta take this serious, get this done.
How long a period of time was that in between? When you first went down there and and then you went back and she told you couldn't?
I went within like 4 days, whatever it was the first,
I know, but
Tuesday
after
of the
that, how
following
long?
week. It was Tuesday of the following week that we had that on the Wednesday. I went down there, got the application, asked the information about, all they asked me was if I was the owner. They didn't ask me if it was my primary residence. I didn't understand that that's, what I should have told them. So that was why, then when I went back to file for the permit, then that's when they said, well, you can't do that because it's not your primary residence.
That's what I'm asking you, not understanding me. How long a period was that when you went back to file from the first time you went?
My house. So after I filed, after I got the information, I went, right after that, we went away for 5 days. We had a
That's what I'm
vacation.
saying. You should take care of your business first. That's what I'm getting at. Instead of leaving all the time, going out of town like everybody wants to do, take care of business. That's where you're going wrong.
So we need to move forward here.
Can we give them some time or not?
No, what's the city? The city, didn't you say 30 days or?
I don't mind giving time. As I stated before, it was here last month, and we went ahead and continued it till this month, and the actual permit was applied for on November 14th. And again, he cannot get that until a certified plumber goes in and applies for the sewer and cap. So why that's not in place, I'm really not sure.
Have you talked to a plumber?
Yeah, absolutely. I have Duncan Plumbing, and they're gonna do the work. And I have the permit right here, not the permit, I apologize. Their proposal right there, right here.
And do you know how much it's gonna cost you to tear the building down?
It's about $6,500.
Okay, so he knows that. So if you had said you didn't know, then we would have a problem. But you know, let's just get it done.
Once you pull a permit, you get 6 months. It's just the process. Let's just get it done. is
Yeah,
my-
listen, we'll give you 30 days,
but
we don't want to see.
30 days.
Well, if
Well,
we give them
whatever.
extra time, which is fine, it's not just getting the permit, it's ripping it down. So if we're saying 30 days, so you can get the permit and rip it down in 30 days, I don't know if he's gonna be able to do that.
Well, the only reason I can't do that is because of the tenant that's in 509. And to do the sewer cap, they're connected to the one. So I can't demo 912 without demoing 509. So, I mean, if I got the
So you're gonna
permit,
tear
it's
both
for
buildings
6.
down?
Yes, sir.
There's a plus there. There's a plus.
So what?
How about January 24th? You think you'd have everything done by January 24th?
If the gentleman, yes, if he moves out, like he says he's going to, and he moves out on the first of the year, I will have it scheduled to do right away. Absolutely.
Okay.
Schedule it now for the.
I'll say this, sir, if you come back and you don't have a signed agreement with the company that's gonna tear the building down, it's not gonna work well for us.
Absolutely not.
Okay, let's make a motion. Let's make a motion, and now you know.
I'm still confused about Inspector Phillips, Specialist Phillips. What is it you wanted regarding fines?
I don't want fines right now.
Okay.
I want to be able to give time, but I think the gentleman should meet a time frame. It's
I
not
agree.
that difficult.
Yes.
January 24th?
If that's what we want to give, but that's for the sewer and cap, which has to be done first.
And the demo.
Then you get the demo permit.
And the demo permit.
January 24th total.
Well, here's what I would say, is that we'll continue the affidavit of noncompliance till January 24th. When we come back on January 24th, it's either demoed or it's not. If it's not demoed, then we, the city, are no longer going to,
Agree to stuff like
agree to any further continuances.
24th, is that the meeting date?
Whether it wants to accept it or not.
22nd.
22nd, okay.
22nd.
22nd it is.
I'll make
So, can I ask a question then? What if there is an issue and that gentleman does not move out?
There's an eviction process.
I'll tell you,
Why
January
is he not-
2nd,
I
you
mean,
better let
if
them
that
know.
happens and he tells me the 24th, I can't file for an eviction and have him out by the 24th. So, I mean, I can't file for an eviction when he's telling me he's gonna move out on the 24th. And I appreciate exactly what you're saying, I understand. And I really appreciate what you're offering. But if he doesn't move out and I have that time frame, then I have to file for an eviction. So I will have the
Well, how about
permit.
this, let's continue it to February.
Gas and
So
water.
then you'll have until February to get the guy moved out and
Okay.
Yeah, evictions
So,
take
you know,
6 weeks.
Yeah, why do you have to, this guy, is he a hardship, or?
Yes, he has, unfortunately, I acquired the guy from my father-in-law. My father-in-law was very sick. The guy he's never paid a penny in the entire 5 years that he's been there, but my father-in-law didn't want to kick him out.
Didn't he sit here one time? Didn't he come in, the tenant, or maybe I'm?
No,
thinking of
that
another
was a different case.
That's a different,
Yeah.
okay. All
So,
right, we're ready.
but I mean, that's the issue, and I'm wholehearted.
Yeah,
I'm
that was
sorry.
a different case. The guy sat there with a smirk.
Yes, but it expired, it had a lease with my father-in-law had it, but it expired.
We're never gonna get done here.
so you're doing it a month.
He's getting even for.
More.
You give him 15 days right now and he would be out. Well, yes, you can.
Now we're pushing it out to February.
This is, I don't know, his name is Robert, something, I don't know, but he's been a thorn in my father-in-law's side for.
Okay, let's
I'll make a motion, Mr. Chairman. I move that we continue case 114-19 to February 26, 2020.
Second.
All in favor? Opposed? All right.
You need to get it done because you're gonna run out of favors. I can tell you.
Okay, moving on. 5.5.
Thank you very much.
Case 136-19, accept the affidavits of noncompliance for respondent Star Cleaners of Tampa Bay Incorporated at 19080 US Highway 19 North for exterior surfaces. Are they here? Inspector Knight?
You can just
No,
do
Sean.
all
You could just say, if there's
That's the
somebody
truck,
here, you
is
can
that the truck rental place?
Yeah, I remember
Okay.
now.
We can accept
Ah.
all of
We can accept them, they're not here.
All right.
All three of them.
All three of them. Will
Yes.
somebody make that motion?
I move to accept the affidavit of non-compliance and issue an order that states if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Okay, other board action,
No other
7.
board action,
Yes, oh, yeah, yeah.
Other board action. Is there other board action?
no other board action, just the nuisance abatement.
Nuisance abatement lien filings. Do I have a motion to accept? Nobody's here, right?
Yes, you can accept both of them.
So I need a motion to accept. I think there's 2 of them.
Okay. I move to enter an order finding that the respondent in violation of code and requiring the response to correct the violations within 30 days?
No, 5 days.
5 days
Right.
of the board's written order, or 5 days of board's written order, period.
Have a second?
Second.
All in favor?
Aye.
We are adjourned.
Happy Thanksgiving.
Yeah.